Hello, I'm Andrew Buddha, DUI attorney with offices in Tampa and Orlando, Florida. Today, I want to talk to you about a question that I get a lot of times when family members or friends or a spouse are in the car and their significant other is arrested for DUI. And that question is, how long until they get out? How do I get them out of jail? What happens now that they've been arrested? What is that process like? So today I'm going to briefly answer that question. Once you are arrested for DUI, there's three scenarios that have to happen before the police will allow you to be released from jail. Number one is that they have to figure out that you are no longer under the influence of any kind of alcohol or controlled substances and that you're safe to go to be released or post bond. Number two is if you take a breath test and your breathalyzer sample is under a 0.05, that's another way they'll release you. Or, and this is the typical, most of the cases will be this one, is that after 8 hours have passed since you've been arrested. So that's what I typically tell people that call me, is that a good rule of thumb is that if your significant other, your friend, or whoever it may be is arrested at, say, midnight, you can expect them to not be released until 8 a.m. That same day at the earliest. Now, some things that you can expect if they've been arrested is that they are going to go through booking. Once they get to the jail and prior to booking, typically they will read them something called implied consent. And there's going to be a video on exactly what implied consent is. So if you want to find that video for more details, you can look for that now on the channel. However, implied consent just tells you that because you hold a valid driver's license, if you refuse to provide a lawful sample of your breath, your license will be suspended. So that's what they're going to ask you typically when you get to the jail before booking. Once you get into booking, they're going to take your mug shot. They're going to check your height, your weight, your vitals. They're going to ask you personal information. Where do you live? Your address. Everything that you would think is just kind of common to make sure that you are going to be coming back to court for the criminal case that goes forward. Now, another question that I get that's very common is, okay, so I've been arrested for DUI. My significant other's been booked. How do I get them out? So, like I said, you wait the 8 hours. The next step that you have to do is you have to post a bond. Now, every single county in Florida is going to have a different, what they call a uniform bond schedule, and that is the county decides what is the appropriate amount of bond for second degree misdemeanor, first degree misdemeanor, third degree felony, second degree felony, first degree felony. And that's going to be all standardized. And that's what the jail uses, that bond schedule, to determine how much it's going to cost you to get out. A good rule of thumb for a first-time DUI, you can anticipate $500 bond. It could be more, but typically it's not going to be any less than $500. Now, I will say this, that if you're unable to post your bond, within 24 hours of being arrested, you will go in front of a judge that does what some counties call it first appearance, some counties call it advisory judge, and it's the same exact thing. Constitutionally, you are allowed to see a judge within 24 to 48 hours after arrest. Again, most of the time it's going to be 24 hours, and that judge is going to read you what you've been charged with, and they're going to talk about what the bond is and if you could afford a bond and if you can afford the lawyer. Now, a lot of times if you're sitting in jail and it's been past the 8 hours and you go in front of the judge and the bond's $500 and you don't have any kind of criminal record, a lot of times a judge is going to release you on your own recognizance, meaning it could be supervised or unsupervised. But what that means is that you're standing in the community and your lack of a criminal history, they believe that you don't have to post a monetary bond to get you to come back to court, because everyone needs to understand that the only point of a bond is to guarantee that you are going to come back to court. They do that because they want to basically to have some skin in the game, if you will. They want you to have some sort of an obligation to come back. So some people just can sign their name and that's just enough that they promise to come back. A lot of times we see that with first-time offenses and DUIs. Hopefully you can afford the $500 bond, but if not, that's what you want to ask for when you go and see the judge at the first appearance court, is to be released on your own recognizance, or ROR. The next thing that you need to know about is once you're released from jail, there's a couple of things that I suggest everybody know and do. You're going to need to make a decision on what you want to do at that point. Are you going to apply for a business purpose only license, or are you going to fight the driver's license suspension? There's another video that I've made discussing the different options and the ramifications. Most people are going to choose to get a business purpose only license because if you do that within the 10 days that you have to, a lot of times if you act quick enough, you can avoid any disruptions in driving to work. And especially in the Tampa Bay and Orlando area, I know that a lot of people commute to work. And they use that car to drive to work, so they can't afford to not have a driver's license. And you are eligible for that most of the time if it's a first-time DUI. If it's a second or above, you are not eligible to get that business purpose only license. Therefore, the only option you really have is to fight the suspension. Again, there's going to be another video on that, so go ahead and check that video out for more information. Now, the other thing to do is to check if your car was towed. You want to get that car out of impound as quick as possible because they're going to be charging you a lot of times by the day to impound your car. So you want to get that out as soon as possible. And then the next court dates that you need to worry about, and there will be detailed videos explaining what each court date is, but depending on each county, the first court date is going to be the same no matter what county you're in. It's called an arraignment. If you hire a private attorney, most of the time that attorney, I know I do it, is going to file a document that allows you to not have to go to the arraignment, allows me to not have to go to the arraignment. And that is because in an arraignment, you go in there and the judge is going to ask you, along with 100+ other people, are you guilty or you're not guilty? Obviously, regardless of if you are actually guilty, procedurally, you always say you're not guilty. And then the second question the judge is going to ask you is if you can afford an attorney or you're going to hire one yourself. That's all you do at that court date. And then it's reset. And again, the next court dates are going to be called, depending on the county, disposition, pretrial, or case management. They call them different things in every county, every jurisdiction has a different way they do things. Essentially what that is it's a court date that you go and you try to either resolve the case, or if there's issues, your attorney will try to get the discovery, which is the police report, any videos, body cam videos, breath tests, DUI packet. There's a lot of different things that go on in a DUI, but that happens at those cases. And then, at those hearings. And then it will be continued usually 30 to 45 days until the case is resolved. And the resolution could be you get a really good deal and you want to take that deal, or in the alternative, you decide that you don't want to accept the deal and you're going to take the case to trial. And either way, that's what you can expect if your friends or loved ones have been arrested for DUI, and what the bond is and how to get them out. You can always call a bondsman to help you with that bond, and they're going to typically charge you for a $500 bond, they would charge you 10% or $100, whichever is more. So obviously a $500 bond, 10% is $50. So you can expect to pay a bondsman a $100 fee. Now you don't get that fee back, but you don't have to post the whole $500 bond. They'll post that on your behalf. Or you could post the bond yourself. Now, once the case is over, you can get that money back. However, if the person who has been arrested posts that bond and it's a cash bond, a lot of times they will apply that money to the court costs or fines once the case is resolved. But it's like you're going to get that money back because it's going to go to those fines, which you have to pay anyway. So if you have any questions, feel free to reach out. Glad to answer any more questions if this video didn't answer those questions, or you can scroll through the channel and try to find other videos with topics that pertain to your DUI case. Again, my name is Andrew Blvd. I'm a DUI attorney practicing in the Tampa Bay and Orlando area and all over the state of Florida. Thanks for watching.